Good afternoon, and thanks for joining us in this seminar on the recent decision of the BVerfG on the ECB public sector purchase program. First of all, I want to thank Matthias Goldmann, a dear friend and a colleague, who helped me in organizing very quickly this moment of debate. And also a special thanks to our speakers, Professor Renè Smits from the University of Amsterdam, Professor Teresa Violante from the Max Planck Institute, and Professor Dani from the University of Trento. Thank you for having accepted our invitation so promptly. So the aim of this moment of discussion is to open the debate about the important decision issued by the BVerfG. This judgment represents, of course, another interesting step of the BVerfG jurisprudence dealing with the European integration process, its limits, and its relation to the state sovereignty. However, this represents a kind of heavy step because for the first time, the BVerfG declared an act of the Court of Justice and an act of the European Central Bank ultra-virus. So we would like to reason now about the implications of this judgment, which deals with several aspects of the European Union and of the European Monetary Union. We can identify several sets of implications of this judgment, and I just want to highlight three main points that I think that are important to be considered. So the first one is the impact of the judgment on the ECB PSPP. However, this seems to be, at least for now, the less problematic consequence of this judgment. But I'm also curious to hear from our speakers what they think about this. The second is the impact of the judgment on the pandemic emergency purchase program, so on the response of the ECB to the coronavirus crisis. And even though this ruling does not apply to this new program, however, the limits that the German court identifies on the role of the ECB, on its mandate, on its powers, of course, cast a shadow on the new program. And also, in general, this judgment seems to weaken the position of the ECB within the EU architecture, and also questioning its independence in a very critical moment like the pandemic. Third, there are heavy implications on EU law in general, and on the relationship between the Court of Justice and the BVerfG and the other national courts. Of course, there are tensions which are inherent to the very same nature of the European Union, as also the court is aware of when the court says at paragraph 111 that in principle, I'm quoting, certain tensions are thus inherent in the design of the European Union. They must be resolved in a cooperative manner in keeping with the spirit of European integration and mitigated through mutual respect and understanding. But in this judgment, the German court seems to adopt a very confrontational register when, for example, clearly declare that the Court of Justice acted ultra-virus and that its judgment has no binding force in Germany. paragraph 163. What strikes me the most is the little attention given to the systemic impact of this judgment. This position taken by one of the most relevant constitutional courts in Europe cannot but have an echo within the EU legal system as a whole. And I think this is even more serious now when the European Union and also the European Court of Justice are dealing with the challenges posed by illiberal regimes within the European Union. This is the point that has been highlighted by the first comments to the decision. And again, I think it's also relevant that the Bundesverfassungsgericht seems to act in isolation without considering to be a key actor of a multi-level, of a composite legal system. It seems to take a kind of autarkic approach towards the European Union. I share the view expressed by Professor Maduro in his comments to the decision when he says that this seems to be the wrong decision at the wrong moment. So I think that it is important to open a debate about the possible implications of this judgment, both on the side of the legal consequences, but also looking at the possible economic consequences of this judgment. Indeed, one of the most important aspects of the decision is the distinction between monetary policies and economic policies. And so this is a relevant part of the judgment, and it will have for sure a huge impact also on the future development of the European Monetary Union and on the steps of the European Central Bank in dealing with the current pandemic crisis. So I would like to open this moment of discussion, and I give immediately the floor to Matthias Goldmann. Please, Matthias, the floor is yours.
So there has already been a lot of critique, but also a persiflage, I would even say, and a parody of that judgment. I don't want to go further down that road. I agree, I guess, with a lot of the critique. One cannot excuse the political blindness of the court to take such a decision right now. Judgments always have to be are contextual. In 1993, when the court started its current integration jurisprudence with the Maastricht judgment, it was quite okay to demand more democracy from the European Union at the point when integration was deepening. We're now in a very different context, and some of the concepts that may have worked in 1993 have to be rethought. I think that a lot of what the court said yesterday is water on the mills of radical powers that will use it to spin the idea and to spread the idea that the EU has violated the law, in one go since the financial crisis and also during the refugee crisis, and is just simply illegal, and that serves to delegitimize the EU for political ends. So, but I won't talk about that anymore. I want to try to find three positive aspects. How could the yesterday's judgment, and maybe in ways that were unintentional, contribute to progressive politics? I think there are three aspects that one should single out. The first aspect has already been mentioned by Antonia. It doesn't mean the end to PSPP, to quantitative easing, nor does it necessarily mean the end to PEP to the corona response adopted by the Euro system. Both of these programs would have to be adjusted probably, and we can later discuss how that is to be imagined. Miguel Maduro said that Article 123 would have to be carefully considered for the corona bonds, but nevertheless, on the whole, yet again, and I think this is a series, the German Constitutional Court does not jump into high politics and does not want to jeopardize economic politics. What its focus is really on legal politics, on this defamed judicial dialogue. And so, from an economic perspective, so to say, that's already good news. So that's my first point. The second point concerns what they say actually about the limits of monetary policy. It is clear from the judgment that monetary policy has to define its limits and that there needs to be some space left for fiscal policy. I guess in the context of the European Union as it stands at the moment, that might actually be a very useful reminder not to forget about fiscal policy. The problem, or the reason why Mario Draghi resorted to whatever it takes to the OMT program in 2012 and then later on to quantitative easing was not that he wanted to provoke the Karlsruhe court. I mean, there's no doubt about that. The reason was that fiscal policy lacked the necessary European solidarity to allow investments, to allow less austerity, to allow just government policies that would contribute to growth. So there's a lack of fiscal policy is the real problem, and monetary policy, I think, has always been reactive to the lack of fiscal policy. Now, if there's some, I think the only or a productive way of getting over that and going back to fiscal policy would be by constraining monetary policy. And that's exactly what the judgment does. At the moment, some of you may have observed the discussions about the recovery fund, this 1.5 trillion fund that has been announced by the European Union to overcome the corona consequences, is in a very difficult situation. Germany says already, we don't want to have the mutualization of debt in that framework. The European Union wants to do it by own resources, but then where should these own resources come from, if not from the households of the member states? And that is a bit of a tricky, I would even say, an impasse, a dead end that threatens to lead to nowhere, so that we would again see monetary policy do the dirty job of overcoming the crisis. And I think with this judgment, this locking in of monetary policy might ultimately move policymakers a little bit towards recognizing the significance of fiscal policy. That's my second point. And the third point, you see I'm very political here. I'm not so legal, but I'm not sure whether that is true for the third point. Now, the third point is actually the most important point I want to make. I think that this judgment, yesterday's judgment, although unintended, means nothing but the beginning of the end of monetarism, or the beginning of the end of ordoliberal monetary policy. Now, what is ordoliberal monetary policy? I guess most of you will know that, but since there are some students among us, please let me briefly explain it. The idea of monetary policy is that of monetarism and ordoliberal monetary policy, which is more or less, the variations of one common theme. The idea behind it is that monetary policy should not be in the hands of governments. Monetary policy allows those making monetary policy to provoke or to trigger short-term growth effects. You just put money on the market that will lead to a short-term growth effect that might help you to get over an election, and then after the election everything collapses and you just end up with more inflation. And that is so tempting, or it has been considered to be so tempting for policymakers to create such a moral hazard that one does not want governments to do monetary policy. Therefore, we have got independent institutions, but to restrain them, and to control the policy effects that they might cause, they are strictly obliged to follow the idea of price stability, even though the exact mandate of different banks around the globe is a little bit different. On the whole, central banks consider it as their primary target, mostly as their primary target, to ensure price stability and nothing else. And that can have disastrous social consequences. For example, when the Federal Reserve decided to step up its interest rate in, I think it was 1979, 1980, in order to fight inflation in the United States, it caused a massive capital flight from the developing world, which then led to the most massive debt crisis the developing world has probably ever experienced, lasting for 1.5 to 2 decades, with terrible consequences on growth, employment, and also the human condition. When the Bundesbank decided in 1990 that German reunification required higher interest rates for Germany, the Deutsche Mark, which then was a dominant currency in European Union, also created a similar pull effect, and a lot of capital from the other countries like Italy or Great Britain went to Germany, and it brought the European system of the predecessor of the European Monetary Union, this European monetary system, to a collapse, which was meant to enable an equal development in different countries of the common market. So it also had disastrous effects there on other countries, but also within Germany, because within Germany it caused nothing but a recession. It was very good for rich people with savings. It was very bad for salaried people who got out of work. So and that is exactly what monetary policy, what monetarism and order-liberal monetary policies want. They want it to be like that. The European Central Bank should be blind to the social effects. And on the whole, the German Constitutional Court starts its judgment as a defense of monetarism. Does the European Central Bank stick to its mandate of pursuing monetary policy? That's the outset. But then something gets in the way. And that something is their eternal fight with the European Court of Justice. And they happen, and they're urged, so to say, to teach the European Court of Justice a lesson on how to do a proportionality check. And so they come up with the idea that proportionality should also include a consideration of the social and economic consequences of monetary policy, meaning exactly the opposite of the monetary policy program. It's nothing but the exact opposite, because they frame it as a question of price stability. Price stability and monetary policy, so to say, should define the border between legitimate monetary policy and illegitimate social economic interventions. But by defining that very border, you have to do monetary policy, because the border is a question of monetary policy as much as of economic and social policy. By defining, for example, what level of unemployment is acceptable, or by defining what impact on savers, on savings in the European Union is acceptable, or by defining what level of financial stability is acceptable, or what growth rate you would like to have, you're automatically making economic policy decisions, not just strictly understood monetary policy decisions. So they're going decisively beyond what the textbook of monetarism wants a central bank to do, and literally force it into into economic policy if only for the purpose of defining the borders of legitimate monetary policy. And I think it is my hunch that they were unaware of it. I do believe they were unaware of it, because they're completely focused on how to do a proportionality check. The European Court of Justice showed a lot of restraint in its proportionality check back in 2018 when it was deciding that issue, even though it went quite to some lengths to check whether there are any less incisive means, etc. It ultimately showed a lot of restraint in respect of the so-called proportionality in the narrow sense, meaning a weighting and balancing of the consequences. It only checked, well, will the financial impact on the European Central Bank be controlled? Does the European Central Bank everything to control its own risk? But it never went into the question of the social effects and the wider economic effects. And I think this is exactly because they thought if we go into that territory, then Karlsruhe will say, you know, what the European Central Bank here does is monetary policy, is economic policy. It's not monetary policy. Yeah. And now, perversely enough, by probably overlooking or by this clash of two interests, you know, on the one hand, defending monetarism, on the other hand, imposing an idea of proportionality on the ECJ, something which goes far beyond the case at hand. By the combination of these two lines of thinking, I think that the Federal Constitutional Court unintendedly put an end to monetarism. Now the central bank has to base its decision on a weighting of the effects. They do that already to some extent. For example, the European Central Bank is always looking at, are we causing any bubbles on the market, etc. So they do that already to a considerable extent, but they've never made it public because they don't want to be political. Now they have to be political. And for me, and I'll leave it with that, that really raises the question whether the European Central Bank can still be an independent technocratic institution. The alternative would be A, you give that competence to the Commission or to the Council, and you go back to where we were before the introduction of independent central banks. Alternative 2 would be you establish an independent but democratically legitimate central bank that is voted by the parliament, maybe even by the people, but probably by the parliament on the basis of a social and economic policy program. Thank you very much.
Thank you very much, Matthias. And now I want to give the floor to Professor Renè Smits, Professor of the Law of Economic and Monetary Union at the University of Amsterdam. Thank you, Professor Smits, for being with us.
Thank you very much. Thank you very much for inviting me. And before I start my comments, I'd like to say that I'm a little bit emotional to be in the midst of that many people from mainly Italy. And I want you to know that I hope that you're in good health, and that our hearts and minds have been with you in the last couple of weeks, and that I'm glad to see all your faces here, and that I feel privileged to be able to participate. What I will be saying is, of course, in a private capacity as an academic. First impressions only. I listened to Franz Meyer, the University of Bielefeld yesterday, who said, this is a judgment that we'll probably have to read several times and find new things in. I've not yet had the time to do that several times. So first judgments on this judgment from my side. Judgment that I will fear has opened another chapter in what Meyer called La guerre des juges, which is ongoing. I'd like to have three perspectives on the judgment: horizontal, vertical, and fundamental. The horizontal line, as I would say, the axis, has to do with monetary versus economic policy, the distinction that also Matthias, you mentioned, which was made in Maastricht, we all know, because of competency reasons, member states fearing a loss of sovereignty in the economic policy field and relying on the markets to discipline governments. A fallout, as I would call it, of the Thatcher-Reagan doctrine of the 1980s. This is Maastricht pur sang. This is the time of free markets, liberalization, privatization, even of essential services. We've seen where that led. It failed us in the last crisis 10 years ago. It fails us with the prospect of climate change, and it fails us in the pandemic. So I think that this whole idea of being able to split monetary and economic policy and have economic policy prerogatives very much within the confines of national powers is something that this judgment puts into sharp focus, because it's that distinction between powers that are European and powers that are not that is one of the cores of its reasoning. And I would argue that, to become also positive, as Matthias wanted to be, on the basis of what happened yesterday, stronger economic policy powers for the EU, so that the whole burden does not fall on the Eurosystem's shoulders alone, is something that I would see as a hopefully positive result from yesterday. On the same horizontal axis, the independence of the central bank, I find it very ironic that it would be a German constitutional court that finally imposes upon the German government and the German parliament to fulfill their obligations, if I read it correctly, vis-à-vis their citizens, to ensure that there is a proper proportionality test by the European Central Bank, and that they should guard against decisions which are not in conformity with the proportionality principles. And even within 3 months, there's even a time limit given. I understand why that is, so that there is some possibility of redress, but it seems rather intrusive for a central bank that is mandated not to be given instructions from politicians. On the vertical axis, vertical in the sense of supremacy of EU law, primacy of EU law, there is no surprise here. We've seen this brewing since 1974, the Zolange I decision, since the Maastricht-Urteil, very much so since the banking union decision of, I think, the 30th or the 31st of July last year, I didn't check the date, in which the Bundesverfassungsgericht decided that it was within the competences of the European Union to give the ECB these prudential supervisory powers, based on a reading of a major judgment of the European Court of Justice, the L-Bank judgment, which was complete reverse of how, at least I read that judgment. But it is an indictment of the Luxembourg judges by the Bundesverfassungsgericht. Let me just cite what they said on their own side, which of course you all have read. The review undertaken by the Court of Justice of the European Union with regard to the to whether the ECB's decisions on the PSPP satisfy the principle of proportionality is not comprehensible, nicht nachvollziehbar, denke ich, dass das auf Deutsch war. To this extent, the judgment was thus rendered ultra vires. I've never read a judgment from one judge about another, not a lower judge, but another judge, in my view, a higher judge, to say that. There is lip service, of course, in the reasoning of the Bundesverfassungsgericht to the unity of law, to the primacy, but I was shocked to read this. Can I say that? Then perhaps final remark, the fundamental approach, what I think underlies this whole reasoning is a view of the European integration project, which I consider, which I don't follow myself, which I consider narrow and based on black and white. I would call this dualistic thinking. Something is either this or that. And that's a way of thinking that we're all falling prone to as humans, but I think a Supreme Court might be invited to go beyond that and to be more imaginative. If I read the line of reasoning of the German Constitutional Court correctly, then it bases itself on the existence of one people, the German people, and one type of democracy, nation-state democracy, and it is the guardian of that identity of not only Germany, but also of the German democracy. And it fails to understand that there is an organization which may not be a fully superstate or a full federation, but which has these same safeguards, as Matthias, you have already mentioned, since 1993 for democracy and certainly for human rights, that can allow an opening to federal or semi-federal decision-making, which is in conformity with the integration clause of the German constitution. What I think we need, and that's what I want, the note I want to end on, what I need is imaginative thinking, both as lawyers, but also as citizens. And I'm going to refer to you once again, Matthias, and then I'll stop. I liked what you said about wider policy objectives. I think the ECB was already in the process of thinking more broadly with its monetary policy review, where climate change and biodiversity, as Christine Lagarde always adds, were at least to be included in the concepts of what is the effect of monetary policy, how should we establish it for the future. Article 3 of the Treaty on European Union, to which the mandate of the ECB, the ECB specifically refers, as many other elements beyond just price stability. And what I would hope, to end also on a positive note, is that the combined challenges of what we are undergoing now, the pandemic and the recession, or perhaps even depression that we are going through economically, and the further longer term challenges, climate change, etc., would combine to help us think imaginatively, also as central bank lawyers, if I can call us such, for a recovery that should, in my view, be green. Let me end on that note.
Thank you very much, Professor Smits, for your very interesting comments. I have already questions, but I will leave questions for the end of our first set of interventions. So I'm very pleased to introduce Professor Teresa Violante. She is a professor at the Friedrich Universität and visiting professor at the Max Planck Institute. Please, Professor Violante, thanks for having joined us, and I look forward to hearing your thoughts on this decision.
Thank you, Professor Baraggia. I'm not a visiting professor at the Max Planck. I'm a visiting research fellow, and I'm a research fellow at Friedrich Universität. Thank you for introduction. Thank you so much for inviting me, and I'm very honored to be able to join this virtual floor and put some questions forward, because at this moment I really have more questions than certainties regarding the decision yesterday. And I think that is very clear if we read the headlines of the European media yesterday. We see how the decision has raised different reactions in different countries and also in different sectors of the media. So certain news outlets were saying that the German Constitutional Court had just put a halt to the further integration of the Economic and Monetary Union. Others said that it had cleared the ECB's program with conditions. So I think it's like a literary text. It raises several different interpretations, and we will not know the end of this until we see the next chapters, and we can be sure that there will be next chapters. As constitutional lawyers and European lawyers, we all knew that this day was a risk and that it would probably come, the day when constitutional law and European law would finally clash in its shared claim to primacy. So we knew that this day would probably come, and I think it was also clear in the incremental approach evidenced mainly by the German Constitutional Court. This is a story that, as Matthias has already stated, has begun many years ago, but the plot became clearer with the first reference, and even more clear with the second one. So my first question here is, in the current state of the European process, what do we expect from constitutional courts, from national constitutional courts, that they are faced with sometimes contradictory constitutional mandates, mandate to remain faithful and to cooperate and to adhere to European integration, but they also have to preserve constitutional identity and national sovereignty. And that would be my first remark. What do we expect of national constitutional courts, especially when the political process is so hesitant, and more than hesitant, is so nuanced and so multi-layered? So this is also a question that is relevant regarding the European Court of Justice, but it is very relevant to national constitutional courts. And coming to the second point that I will refer, and taking into account the comment that Miguel Maduro, Poyas Maduro, has published today at the Verfassungsblog, blog, where he draws a parallelism in the behavior of the German court with the behavior of the Portuguese Constitutional Court during the austerity crisis, that he labels as parochial, because it fails, according to his perspective, to take into account the commands that a multi-level order demands. And I think that the Portuguese court's reaction was even more parochial, but I think for good reasons, I must add, because it didn't even refer any case to the European Court of Justice. But we failed to have an adequate institutional framework that allows this relationship between national constitutional courts, the ECJ, and the EU legal order. So, as a constitutional court, and we know this is classic constitutional law, you know that constitutional courts eventually, once in a while, will interfere with the political process. They will block political options. They will function as veto players. That is something that is not unusual for a constitutional court to do. So in that regard, I don't think it's completely unusual to have that kind of reaction from a national constitutional court. Of course, we can say that the systemic effects are disastrous, but is it really the German Constitutional Court to blame for that? How did we come to this position when courts, be them a national constitutional court or the European Court of Justice, are faced in the middle of the storm, and they have to choose between acting as apologists for the ECB's policy to save the Eurozone, whatever the cost is, or to step in and put blockages to the stability of the Eurozone. How did we come to this when the court is faced with this challenge? So I think that more than focusing on the court's rulings, we should turn the table to the political process. And I think that to take the optimistic view that Matthias also introduced, I think that it's a good way to read the decision yesterday. So from a constitutional law perspective, this decision does not close the interpretation process. The constitutional conflict is not closed by the decision. It doesn't block anything. The program keeps going, and there is a 3rd-month moratorium for the proportionality review to be duly conducted. It doesn't order the ECB anything. It orders the national institutions to gather that justification by the ECB. So I think that looking at the effects and the implementation of the decision itself, it is a dialogic decision. It proceduralizes the review, so it doesn't conduct in its ratio decidendi a substantive assessment of the ECB. It's a proceduralization which in itself allows for, is in itself a more dialogic tool that courts, especially constitutional courts, use when confronting difficult political decisions. It turns back the table to the political process. And here, just to conclude these very brief remarks, I think that what the court opens the door to, or more than that, appeals to, is to institutional imagination, especially from the political actors. So I think that the burden now lays more on the hands of the political actors, and I think it conveys an important message, although its legal effects are only directed at the German politicians. It conveys an important message to other national politicians from the fiscal hawk sector. So it's really coming to that stage where the political process will need to make a definite choice on whether to take one step up and enforce risk-sharing policies, or to leave the situation as it is. So this would be my first comments/questions on the decision.
Thank you, Teresa. Thank you very much. Also for this optimistic view about the decision and its consequences. And now I give the floor to Professor Marco Dani, Professor of Comparative Law at the University of Trento. Please, the floor is yours.
Thank you very much. I would like, first of all, to thank Antonia and Matthias for having set up this webinar and to give me the opportunity to share some thoughts. First of all, I must say that I have read the judgment, of course, but I haven't studied it thoroughly. So I think that, and this requires time, I think. It's a very rich judgment. And what I'm going to say is mainly something on the context of the judgment and on why I think, I'm afraid departing from what Matthias said at the beginning, that the judgment is not political blind, but it's political aware, in my view. And I understand this on the basis of the context. What is the context of the judgment, of yesterday's judgment? It is a judgment adopted in the midst of an unprecedented economic crisis. And it is a judgment adopted against a backdrop in which we have a highly dysfunctional economic governance. When I say highly dysfunctional, I say because we didn't have all the instruments, and we don't have all the instruments required as a European Union to cope with the magnitude of such a crisis. We don't have a central bank operating as a lender of last resort, and we don't have proper federal fiscal policies. It is a judgment that is adopted in the moment in which the EU was struggling to respond to the crisis. The main responses were taken at national level, thanks to the relaxation of state aid rules and the suspension of the Stability and Growth Pact. Because of this national response, the responses have been so far highly asymmetric. If you look at the magnitude of the aids that have been given, half of those aids come from Germany. So they are not evenly distributed in the common market, and they do not target the most affected economies, most affected by the crisis. So there is a strong case in principle for EU intervention to make up for those asymmetries. But in this regard, there is an ongoing conflict between, as we know, two groups of member states. We could say the willing nine that were trying to have at the beginning of the crisis some sort of euro or corona bond, some sort of fiscal policy, and the frugal four that were resisting that. So for the first, fiscal response and a degree of solidarity is the way to cope with the crisis. For the second group, transfer are accepted, but only in the form of conditionality. So the first group would like to have grants, the second group basically loans, assisted with conditionality, which means basically austerity. Both parties have hidden agendas, or not so hidden agendas, I would say. They would like to use the COVID-19 crisis as a window of opportunities to push forward their long-standing goals. The Willing Nine would like to complete the economic and monetary union with supranational fiscal policy. The Frugal Four would like to enforce, to use the COVID crisis to transform Southern economic and social models in the light of the German paradigm. At the moment, or at the moment in which the judgment was adopted, Northern countries are prevailing because most of the instruments adopted or underway are basically loans. The ESM is basically a program for loans. For SURE is a program of loans. What the Bank or European Investment is proposing are again loans. So very thin solidarity, the solidarity that a bank can offer, a subsidized loan. However, the conflict was, and to some extent is still underway. Debt mutualization remains a taboo, and in all of this, the economic and monetary union and the national economies were surviving thanks to the ECB and the PAPP program in particular. After the initial hesitations, the ECB has stepped up, and with these instruments have ensured the survival of the EMU so far. But for the judgment on the PEPP is a mixed one. If we look at that from a European perspective, from inside the European Union, is a bold move because the amount for this year is quite substantial. It includes long-term securities. There's a departure from capital key rule, which is quite remarkable. In other words, it is stretching even more the monetary policy mandate of the ECB. But if we compare the PEPP with the programs underway elsewhere, it is a rather shy program, in particular in terms of size. And we have even central banks that are directly going into debt mutualization, something which is anathema for the European Union and the European treaties, probably. So at this point, we have a judgment, and the judgment is a judgment that I'm afraid kills the PEPP, precisely because it targets two of the distinctive elements of this program. I think that one of the comments yesterday I've seen in Twitter was very accurate. The Bundesverfassungsgericht shot the PSPP but killed the PEPP. And if this is, I think it is correct, not really because of all the discussion on proportionality. I don't think it is the most problematic part of the judgment, that one. Also because if I know the institutional culture of the European Union enough, this will end up asking the ECB to conduct some impact assessment, as the Commission does. And so to mainstream some proportionality within its decision-making, perhaps in a more accurate way than before. But the most problematic part of the judgment is the part on Article 123, in which it is in that part that we have language that puts the PEPP in a legal precarious terrain. And the damage is not only legal, but it could be also economic. So far, strangely enough, the markets are not responding in a very bad way to the judgment, but I wouldn't be surprised that in the next days, if the PEPP is really considered on a precarious legal terrain, markets will have a different attitude towards sovereign debt in Europe. So what are the implications of the judgment besides undermining the possibility of having the ECB as an institution that is playing that subsidiary role while that conflict between two groups of countries is being carried out? There are two possibilities, two possible implications. The first one is the one that Matthias has articulated very well. This judgment could put an end to the ECB subsidiary role, could put an end to the muddling through that we have seen in the last decade. And in an ideal world, political institutions, national governments would come up and would do something big to make the Bundesverfassungsgericht damage right. So they would take on their responsibilities and they would endow the European Union with some sort of fiscal policy and with the instruments that are lacking so far. The thing is, and I'm more skeptical in this regard, I would say I'm pessimist more than skeptical, for two reasons. First of all, because the conflict between national governments seems intractable. Both groups of countries from their own particular perspective have a very good reason to pursue their own agenda. And I don't see a terrain of mediation, of constructive mediation between the two. And secondly, and most importantly, because there is still room for muddling through in the current institutional architecture. What is the possibility that is open also by this judgment? The possibility is to have the countries of Southern Europe under an ESM program in order to open up for the OMT. The OMT is valid, is fine for both the ECJ and for the Bundesverfassungsgericht. And there you can have the European Central Bank doing the work that has been basically doing in this period, but in a less problematic, on a less problematic legal basis. If this is where the judgment leads us, it is exactly the place where, since the beginning of the crisis, northern countries wanted us to end, in such a situation in which southern countries are under an ESM program, and the COVID crisis is employed to transform, to put an end to the economic and social models. So there is a disabling dimension of the judgment, which is to put an end to the PEPP, but there is also an enabling dimension of the judgment. The enabling dimension is to open the door to the OMT, to open the door to the ESM, to open the door to what northern countries wanted since the beginning. If my analysis is correct, this is a very politically aware judgment, not blind. Thanks.
So thank you very much for this different understanding of this decision. So now I would open the floor to the debate, and I give the role of moderator to my colleague, to Matthias.
Oh dear, okay, thank you. So what I would propose is that instead of raising your hand, just type your into the chat, yeah, type to all, and then, because then we have a list of speakers. If you just raise your hand, it will be very difficult for me. Just make a, say a one or like, I want to talk, and in the chat, and then we can do it like this. Yeah, and then everybody sees it. Ideally, type it to everybody. Although I saw already one hand, as long as you are still thinking about your questions, I saw one hand was raised by Amnon Lehavi. Are you with us? And then,
yes.
yeah, here you are. Okay, wonderful. So why don't you start? Please go ahead.
Okay, so hi, I'm Amnon Lehavi. I serve as Dean of the Harry Radzner Law School at IDC Herzliya, a private university in Israel. I write on property, and I recently published a book titled Property Law in a Globalizing World. So I'm truly fascinated, Antonia and Matthias, about the role of supranational courts. So here's my question to you. So I wonder, what are the broader implications of the Bundesverfassungsgericht, or any other national court for that matter, undermining the methodology and the very authority of the European Court? Will we see, for example, what happens when the Court of Justice of the European Union or the European Court of Human Rights reviews a national law or a national regulation, say a German law, saying, for example, because I come from property, that a certain national law passed by the German Bundestag violates the right of property of German citizens under Article 17 of the Fundamental Charter, or Article 1, Protocol 1 of the European Convention on Human Rights? Will we see the Bundesverfassungsgericht or any other national court saying the reasoning is so bad, the methodology is so flawed, that the decision by the European Court is ultra-virus? So what are basically the broader implications for the authority of supranational European courts when they come into clash with dominant national courts such as the Bundesverfassungsgericht?
Thank you very much, Amnon, for that question. Can I maybe, as it asks a question of German constitutional law, can I perhaps take the liberty of trying to briefly answer, and then anybody who wants to join me in the answer from the other speakers, please feel free. So, of course, it is totally possible that the German Constitutional Court would do exactly as you say in theory. So they could, and any decision taken by an international court could be quashed on the same basis. Nevertheless, it is much less likely to happen in ordinary cases, I would say. Why is that the case? The realism, the political realist would point to the fact that most constitutional complaints lodged by individuals go not to the second Senate, but to the first Senate of the German Constitutional Court. And just a few months ago, the first Senate, and let's not forget about that, took a very important decision on the right to be forgotten, in which they said that, in principle, we consider the German fundamental rights to be in line with European fundamental rights. And European fundamental rights then, are, the Charter says that they should be in line with the European Convention on Human Rights. So we, as our base position is that there is full harmony, so to say. And if there might be a divergence, we will submit the case to the ECJ. Yeah, and in theory, they still reserve the right to diverge and to pull the plug and do their own independent test, but this has become a mere theoretical possibility. So for the large majority of cases, it doesn't really matter. I hope that is what I can say from a constitutional law perspective. Anybody from my co-speakers wants to add something to that? Okay, then I'd proceed with Leonardo. Leonardo De Petris has a question. Anybody else, if you want to speak, please just write in the chat. And
I saw that Teresa wanted to say something.
Yeah.
Okay, sorry, I didn't see it. Teresa, go ahead.
Thank you. Answering your question, and specifically with regards to the Portuguese jurisdiction, and also taking the perspective of a political realist, like Matthias was saying, I doubt that would be the case, because the Portuguese Constitutional Court doesn't put itself in the position where it would have to, and now this specifically with regards with the ECJ, it would not be satisfied with the reply. And I think that was very clear during the austerity case law, where it assumed a completely parochial approach. And it was due to the fact, that is my interpretation, that it it knew that it lacked the authority to disregard or to enter into an open confrontation with the ECJ, like the German court has just done. I mean, look at the German court. It's the most powerful constitutional court in the world, and it took all this time to finally adopt a confrontational stance. And the Portuguese court, the time pressure was very high during those days, so we didn't have enough time to develop a long-time judicial strategy and to enter into an engagement relationship with the ECJ, and it just adopted the opposite approach, not to refer and to completely nationalize the conflicts with clear European effects, with clear European implications. And something that I find curious is that some of the fierce critiques that we find in critical opinions on yesterday's rulings come from people who are very appraisive of the decisions of the Portuguese court, because it somehow questioned the no alternative narrative, and it made possible through a very informal way, in disregarding the need to take into account the multi-level dynamics of the European law, but it found through that way a space to channel into the EU law level, and we can see some of those aspects reflected in the ESM treaty, but mainly in the regulation 472 on the strict conditionality. And it wouldn't have it wouldn't have had that kind of effect had it entered the normal way and made a reference and then received back a reply that we knew during those days wouldn't be up to the ECJ's mandate regarding other EU law values and provisions.
Thank you very much, Teresa. That was very insightful. And let's not forget the Portuguese Constitutional Court is considered by the International Monetary Fund as a risk to growth and stability in Portugal. So actually it has probably quite some influence. Anybody else who wants to address that? I think an Italian perspective on that would be interesting. Antonia or Marco, are you? How would you see that? I think I'm raising the Italy, not just because there seems to be a number of Italians here, but I think the Italian court of constitution called Corte Costituzionale showed how you can also be influential by doing it differently without being so aggressive. Yeah. So why the big question remains: why did Karlsruhe not choose the Taricco road and just resubmit it? And one answer is perhaps, again, from the political realist perspective, that the terms of Voskuhle and Huber are expiring. And it takes time to submit. That's cynical. I don't know whether that played a role, but it's a possible explanation. Okay, so unless there's another, okay, so I'd like to call upon Leonardo. You had a remark, please, and then Nicola.
Okay, thanks everybody for this opportunity of confrontation. Actually, my name is Andrea, it's not Leonardo. This is my son's account, which is why, because in Italy we are using computers all the way for everything right now, since it's the only way for us to contact the rest of the world, let's say. By the way, my quick remark is affecting one of the first sentences I heard in this meeting, which is, was this of yesterday the wrong decision at the wrong time? And I was arguing if it could be maybe said that it was maybe the right decision with the wrong words, meaning that the general aim of the decisions was probably even trying to be positive, mainly trying to put under stress the real problem of the actual economic conditions, the European Union or the Eurozone, the very discussed role of the European Central Bank. So I was figuring out it was possible to read the decision in a way that Karlsruhe is trying to say, let's stop this actual situation and let's try to bring the real thing of ruling the economic politics of the European Union in Brussels, with the Commission ruling this system as it actually is supposed to do right now with the new program, and giving the European Union proper fiscal means, proper fiscal policies in order to avoid the whole discussion about the role of the European Central Bank for the future. But of course, as other people said already, this means that the political actors had to take their own responsibility and do this kind of reform. And the second part is, which is actually a very long-term issue for Karlsruhe, the democratic fundamental of the political decisions in this area, also affecting the European Central Bank and so on. Already in the OMT decision was put under stress the lack of democracy legitimation. So maybe the both things are actually very good points if we really want to see in a European perspective. The point of the question is, my remark is, if the European institutions will be able to read the decision this way and to develop it as is supposed to be mentioned. Thank you.
Thanks, Andrea. I think that was a very good question, but perhaps rather a comment. I'm not sure we need to immediately respond to that. I perhaps, if one of my co-panelists wants, then please signal it to me. Otherwise, I would just continue and ask Nicolas Véran to ask his question.
Yeah, I'm very sorry because I joined late. I had connection difficulties. So maybe my question has already been addressed in the debate. It's a practical question linked to what you just referred to, Matthias, which is the retirement of Chairman Voskuhle today and other members of the court leaving the scene. And so this is really a question about the German court, not about the EU legal order, but do you have any expectations that some aspects of the stance of the court may change over time, or do you think at this point it's really not linked to personalities?
It is, of course, linked to personality. It is definitely linked to personality. Even though the court has been rather consistent over time in its opinions, also because of the fact that decisions tend to be lengthy and they always need to repeat what they've said before, and they never really or hardly ever overrule prior judgments. I think the particular way they took with monetary policy can only be explained through the presence of Judge Huber, who's the reporting judge, and probably the interest of Judge Voskuhle to keep the Senate together. When Voskuhle and Huber came to the Senate around the same time, Voskuhle a little bit earlier, that Senate was highly polarized. Yeah, so the conservatives and liberal judges were in a sort of a fight, and we had, and then it got even worse in 2014. But then some judges retired, and everything became peaceful again. But that peace is actually, I think, it means it's been a total defeat of any opposition to the position of Peter Michael Huber, who, by the way, is a very open-minded person. In he's actively seeking discussions with scholars, etc., and trying to explain the judgment. So it's not that he's solipsistic in a way and closing off different views. No, he's exposing himself all the time, and he's not shying away from getting his share of criticism. So that can really be said in his favor. Nevertheless, as you may know, the term of office of both Voskuhle and also in a little while Judge Huber will expire. And we'll see where it goes. We had an important judgment just a few weeks ago on the European Patent Court, in which 3 dissenting judges said that the Senate, from the very same Senate, 3 dissenters said in a separate opinion that they think the court should restrain the demands it imposes on integration. That was a bit a different problem. You can't compare it so well. It concerned the question whether the European Patent Court needs to have a constitution change, the majority of a constitutional amendment, or whether it can just pass as an ordinary law or an ordinary treaty. And they said, no, let's pass it as an ordinary treaty. Like, for example, investment tribunals, they're also, or treaties establishing investment tribunals only require an ordinary majority. So why make it so difficult for the European integration? That was a first sign that there might be a change in the court, but that is, it's a bit speculative, yeah. And after all, as I said, the court has been rather constant. Okay, so now we have, I guess we still have like a quarter of an hour, so I hope that that answers the question by Nicolas. So I saw that there was a discussion between Renè and Nathan de Arriba-Seye. Do you want to raise that here before I go on there? There's another question by Matteo, and but you're typing a lot here. So Renè or Nathan, if you want to say something, please, here's the floor.
Thank you very much. Not for me on this issue, unless Nathan wants to do that. I have a brief follow-up question, but I don't want to take the time that another person who'd like to have the floor perhaps deserves.
Go ahead.
Question from Matteo. So let me shut up and leave the floor to him.
Okay, Matteo, here's your turn.
Yes, just my question is maybe not on the ruling itself, but more on the reactions on to the ruling at the EU level. And I've been thinking about it and wondering quite a bit in the last 24 hours. And I'd like to understand your views on how, let's say, the ECB and the Commission, and to some extent maybe the Court of Justice itself, should react, and whether they should react at all. Perhaps a bit of a provocative statement could be that there is no need for any reaction. And if we do a little exercise and imagine a similar judgment coming from, Poland or Hungary, probably there will be no formal reaction, and there will be no understanding of a storm and a bomb in the union legal order. So I'm of two minds still on perhaps there should be a clear reaction on the one hand at the ECB and the Commission to tackle the concern of the ECB, of the German Constitutional Court, both on the concrete issue and more generally on the challenge to primacy, which is quite important in my view. Or perhaps we should simply, and I think European players should just simply, keep going and not formally react. Also considering that indeed with the different mandate, with judges expiring, there might not need to be a huge reaction because things will change in Germany itself. So, just sharing it, and maybe a final comment on Tarico and the Italian perspective. Indeed, I agree that was the possible way to go. So maybe I slightly disagree with Teresa Violante in the sense that there was a way to be more dialogical, and the instrument is again the preliminary reference itself. And just understanding your views on this.
Can I say just
yes, please? I wanted to call upon you
on this about a reaction. First of all, I like your idea of not responding at all. Just let the current wave go over, or the fire extinguish itself. The issue, I think, for the German, but correct me if I'm wrong, those who know more about German constitutional law than I do, which is very little. I think the German authorities are under a quandary and need to do something. I'd just like to remind you of the fact that the ECB itself issued a press release yesterday with a very a statement at the very end that I liked a lot, where they referred to the decision of the European Court of Justice in the Vice judgment, saying that implicitly, it's my translation of what they said, we've known since December 2018 that we are acting within our mandate. And I like that kind of reply.
Definitely. Thank you very much, Renè. Is there, I see that the Nathan-Renè discussion has somehow been brought to a conclusion. Is there anything you want to add in that respect? I think it concerned the significance of Gauweiler. But I think we have something in the chat here. I don't see a question at the moment, but I would have a question for Marco Dani. Can you please expand precisely why PEP, in your opinion, would be illegal under the current program? You say that 123 is the problem. Now, PEP is a hybrid between PSPP and OMT. And in my understanding, to the extent that PEP resembles PSPP, it would not go beyond what we've seen yesterday. So the problematic issues arise not. I mean, it's more about, you know, the asymmetry that might cause difficulties, the potential asymmetry and potential limits. But much of that has already been addressed in the Gauweiler case. So can you just expand on it, please? I'd be really interested.
Yes, there's 2 points in this regard. The first one is the issue of selectivity. The way I read the judgment of yesterday, seems to me that the German Constitutional Court is questioning the fact that there could be an intervention by the ECB, which is selective and which disregards the capital key. This is already something within QE1, but it is even more radical in the PEPP. And the way in which I read the judgment of yesterday is that it somehow entrenches capital key as a requirement for an intervention by the ECB that does not circumvent Article 123. This is at least my reading. Secondly, there's a profound difference between PEPP and OMT, and the profound difference is that the PEPP does not have a macroeconomic adjustment program behind. So there's the incentive now is to go to OMT, but OMT requires the existence of a macroeconomic adjustment program. There's some uncertainty on whether it will be sufficient to have the pandemic crisis support under the ESM, the program which is going to be planned at the moment, which is a precautionary line. Here, the ECB says that also precautionary lines open the door to OMT, but the judgments by both the Court of Justice and the German Constitutional Court on the OMT case are very much focused on the existence of rigorous conditionality in the sense of a macroeconomic adjustment program. But in that regard, we have still to see what comes out on the pandemic support.
So order liberalism isn't dead, unlike I said. Okay, thank you very much for that.
I think at least I think there is some degree of denial in the debate I hear. I think order liberalism is thriving after this judgment because it won the case, basically.
That's true, definitely. Even though I would say one would have to watch to what extent one can justify PEP, because it really addresses a different problem. It addresses a concrete emergency, and an emergency that is that has fiscal consequences, but that isn't fiscal in nature. I think that is something to consider. Anyway, there is a question by Monica Bonini. Please go ahead.
Thank you. It's not really a question or a remark. I do not know, but I would like you to help me. So I am missing something here. Mario Draghi has always said that, of course, he was aware, and the EBC was aware, that they were realizing an unconventional monetary policy. Unconventional means that in times of emergency, you have to do something unconventional, as obvious as it sounds. Therefore, in the judgment, does the German constitutional judge somewhere reflect on this problem? Article 123 must be interpreted in normal situations, let's say, or in extraordinary situations. In extraordinary situations may be interpreted in a broader way, and so reflect on the character of the mandate. But anyway, so the problem is, from my point of view, and there I ask you for your help, isn't it that we should introduce an article 123.b.1 and so on, in order to understand how such an unconventional reaction may be the response to emergency times? Do not know whether the question was clear enough, but okay.
Thank you. So the question is whether even monetary policy should recognize something like an emergency, as opposed to...
Not exactly. Draghi has always said, I know that's unconventional monetary policy, but I cannot do traditional monetary policy until the emergency is coming to an end. So emergency means once crisis, financial crisis, today pandemic crisis, okay? But they are aware of it. My problem is it possible to have an interpretation of article and the whole title 123, which also aims to facing with unconventional monetary policy, even if it is not written in the treaty, such kind of emergencies? Does the German judge consider this problem?
I do think they take it into consideration. I mean, it's all a question, you know, it all boils down to proportionality, and I think proportionality in principle is a good way of taking into account such emergencies. Yeah, if you have a proportionality measure, then the question is always, you know, it can vary. The border, so to say, that is admissible for monetary policy will vary with the context. And the context of an emergency is different. So proportionality, I think, is a good measure that provides for enough flexibility to address the issue that you're raising. The question is proportionate to what? Yeah, that's the big thing. That's open. Yeah, but are you? So we have. Yeah, please go. Yeah.
Just 1 second. But so it was important to put the question, but the answer is in the question, because if you say, if the judge says proportionality and ECB answers, of course, it's an extraordinary situation, my monetary policy has to be extraordinary.
I think,
so it's,
yes, exactly. Okay. Yeah, that's, I guess, but I guess that's possible within the framework, the existing framework.
Okay.
Yeah, so there's enough flexibility for that. And the question is really, where do you draw the line? Because the problem is that in emergencies, the distinction between, and under the conditions of quantitative easing, the distinction between monetary policy and economic policy, as Renè said earlier on, becomes obsolete. Yeah. It becomes completely blurred. Yeah. Anything you want to add, Renè, or anybody else from my co-panelists?
Just to get to this point, that there is one sentence in the wise judgment of the European Court of Justice already, where it said something intriguing. Paragraph 60: the authors of the treaties did not intend to make an absolute separation between economic and monetary policies, which is, it hangs in the air. So that's the only remark I have at the moment.
Which says it all. Okay, thank you. So Nicola had another question. Would you mind if I ask Felipe first, because he hasn't spoken yet, and then return to you?
Yes, of course.
Yeah. So Felipe, please. Felipe Burrito Bastos.
Yeah. Thank you, Matthias. So first of all, let me thank the organizers for putting this panel together. I have many doubts about this ruling, both from the point of view of monetary policy, from the constitutional point of view, and others. So my general impression is this: different parts of the judgment yesterday seem to be addressed to different actors. Part of it seems to be directed at the Bundesbank. Part of it seems to be directed at the European Central Bank, in particular when it requires the European Central Bank to balance, as you pointed out, Matthias, monetary policy with other, namely economic interests. But there is also a part, and that I think is for me the part that puzzles me the most, that is clearly addressed to the European Court of Justice, and in particular to its style of reasoning. There is a passage, so one of the most criticized passages in the judgment of yesterday concerns the very blunt accusation that the Court of Justice's reasoning is not intelligible when it comes to proportionality. It's just not comprehensible, as if it had been written in a completely different language, if in human language at all. And that passage very much reminded me of one of the loose strings in the Bundesverfassungsgericht's earlier case law in Honeywell, when it said explicitly that it would commit to accepting rulings of the European Court of Justice, provided they were methodologically tenable, plausible, defensible. I think vertretbar was the word, right? So my question is, do these terms have a robust, well-accepted meaning in German constitutional law, or is it the case, if we want to put it in a provocative, perhaps cynical perspective, that in establishing criteria in the judgment yesterday to determine whether the Court of Justice's reasoning is arbitrary or not, the Bundesverfassungsgericht resorted to what seems to be itself a pretty arbitrary test? Thank you.
Philipp, an extensive answer or comprehensive answer would probably take an hour. So I can't do it. So that was a really massive question. But I think you're quite right in pointing out that the question, it really lends itself, what is that standard that they're applying? And in Honeywell, they said only obvious, structurally, manifest digressions from the proper methodology would amount to a violation of their competence. And now we could even say a disagreement on specifics of how to design a proportionality test, i.e., whether you put the emphasis on the first two elements, suitability and necessity, or on the third element, the proper balancing, really is what it is all about, and brings the court, a disagreement on that brings the court to the conclusion that the ECJ is manifestly in error. I think that says everything about this manifestness. I think they just completely obliterated that, but we could say a lot about it, because a lot more, it wasn't really quite clear even in Honeywell what that would mean. Yeah. But I don't really want to, I think it would take very, very long to go here really to specifics, but I think you're quite right. You could say that even though they don't say so on substance, they're doing a full review of ECJ jurisprudence. Okay, so now we had a question by, or anybody who wants to add something to this, also from the broader audience. German constitutional lawyers might be among us. Okay. If you want, you can still raise your arm or your signal in the chat. Nicola, you had another question. Please go ahead.
Yeah, and that may be another thing that you already discussed. So if so, just ignore it. My question is about the last point of the ruling, at least in the English summary, which says there has to be a decision of the ECB Governing Council on proportionality assessment, otherwise the Bundesbank should exit PSPP. And it's not clear to me how to operationalize that, and especially if there is a possibility that this would be treated as an internal Eurosystem matter. So the Bundesbank could ask the ECB for some you know, report, memo, whatever. Whether it has to go the full way to the Governing Council is an interesting sub-question. But if the Bundesbank replies to the, or sends whatever report comes out of this process to the Constitutional Court, you could say that on the face of it, the condition is met. So have you discussed that, and is it a matter of reflection how to get out of this predicament in a way that doesn't force the ECB to directly acknowledge, which of course it cannot and won't, a direct relationship with the German Constitutional Court?
Although, if I may,
yeah, please, yes, please.
To this, Nicola, although I'm not aware of how this would go on in Frankfurt, I would think that the element that you just mentioned at the end would carry a lot of weight in their considerations. As I referred earlier to the last paragraph of the press release issued last night, I think there will be, and rightly so, a lot of value in this decision to be attached by the ECB to the fact that they don't want to be seen to be bowing to a national constitutional court's order. On the other hand, they can easily refrain from doing anything since this is an injunction, if I'm correctly understanding, Matthias, the German constitutional context. It's an injunction to the German political authorities. And even if they act on that and they ask the ECB for a further reasoning, which of course it has given in all kinds of economic arguments already, but perhaps not in the preamble of the decision of 2015, then the ECB can easily invoke Article 7 of its statute and Article 130 of the treaty, saying we're independent, we don't take any instructions. But yeah, how that would work out, I've got no idea. This is just what I can think of now.
I think we agree on this. The ECB cannot afford to acknowledge direct authority of the German Constitutional Court or the Bundestag or the German federal government. However, there's an exception to this with the Bundesbank, because the Bundesbank is a stakeholder of the ECB through the Eurosystem. So if it's the Bundesbank that asks the ECB for a document, and again, there is a secondary question whether that document would go the full way to approval, for approval to the Governing Council. But if the Bundesbank asks the ECB for a document, the ECB gives the document to the Bundesbank, and the Bundesbank publishes this document or gives it to the German Constitutional Court. Isn't that a way to square that circle? That's my question.
I think that's a very creative idea, right?
I think so too. Yeah, I think so too. The only question that I would have, and I haven't been able to answer that, is anyone able to answer that? The procedure for the Bundesverfassungsgericht seems to have stopped yesterday. There is no sequel to this, or is there, Matthias?
No, that's it. Somebody else would have to sue again, but of course, Bundestag and Bundesbank are under the obligation to implement it, and that also gives them some leeway. So they might decide to accept like a sort of informal document that is not part of the official policy, but contains what the Constitutional Court demanded to be part of the official policy document. Yeah.
And then have that distributed widely, so as to incite further claimants to go to Karlsruhe. Finally, they will. Even if there is no such documents, they will also see that probably as a reason to go to court.
I suppose that someone is already preparing a suit against Pep. It would take me wonder if that was not the case. So therefore, we'll have, yeah, it will continue. Yeah. So Teresa had another question. Yeah, please go ahead.
I'll be very quick. So the main criticism of the Bundesverfassungsgericht towards the ECB was on the, according to the arguments, was on the failure to abide with the duty to provide to state reasons, the duty to justify its program. Do you think that this duty, this failure, could have been at least partially fulfilled had the ECB attended and engaged with the German court in the oral hearing?
I think, honestly, I think it's more a question between courts. Yeah, the German Constitutional Court is unhappy mostly about the reasoning of the European Court of Justice, not so much about the ECB, although that might have played a role. And yeah, so I would say rather it wouldn't have changed it. Also, let's not be mistaken. It's not just a formal question of giving inadequate reasons. They actually assume that there hasn't been a proportionality balancing as they expected. So it's really more it goes a little bit further to the substance. Yeah. So I see that there is a comment by Menendez. Is that Agustin somewhere? Do you want to ask the question? Yes, please, Agustin. Can you put on your mic, or is that impossible? So you're asking. Nice to hear you, by the way, or to see you here. Oh, you have no mic. Okay, so the question is, what if in the next governing council, Weidmann simply states that either an answer is coming from the ECB or the Bundesbank would understand itself to be forced to stop buying bonds? What's left of PEPP? Yeah, it's really the question, who should they obey? They're somehow in a paradoxical situation where they've got diverging legal obligations, and then they can pick and choose. They could, of course, take that position, but they could also say, well, primacy. It much might depend on Weidmann, but there might also be maybe not even so much on Weidmann, because ultimately it will be for Bundestag and Bundesrat, for the government, for Bundestag and Bundesregierung, for the government to decide whether the ECB has complied. So it's not the court wisely doesn't bring Bundesbank into the awkward situation of judging whether the euro system, of which it is a part itself, has complied with its duties. So it ultimately depends much more on government. Yeah, we'll have to see. I think if Bundesbank goes down the road you suggest, Weidmann just says we're stopping buying bonds, then I suppose there might be or there could be a suit for a treaty violation. So Germany could be sued by the Commission in that case, I suppose. Yeah. So there's one question by Antonia to Felipe. To Felipe's question.
It's not a question to Felipe. I want to bring the issue that Felipe has raised about the use of the proportionality test. So, because I found very interesting that in the decision, the court also mentioned the use of a kind of proportionality test by, for example, the Italian Constitutional Court, the reasonable test. But I was wondering whether, so what is the German doctrine about the proportionality test? And they are really talking the same languages about proportionality, because from an Italian perspective, the reasonable test is not exactly a proportionality test. So the national understanding of this general principle is different. And so I was wondering whether some of the German scholars can clarify this aspect, which is central in the argument of the court.
Clarify how proportionality works. Yeah, there is no clear what. Yeah, I mean, there are different models. I think an interesting part of the judgment is where they compare how the ECJ does proportionality reviews in certain areas or in general. I think that's very wise. And, you know, I don't see why that shouldn't be in line with Article 5, Paragraph 4 of the Treaty on EU. It sounds like a reasonable way to do proportionality tests, because the ECJ is putting a lot of effort into getting necessity right, which the German Constitutional Court almost always glosses over. So they're just diverging views. And I wouldn't say there is one way of doing it right. I mean, if you look at the European Court of Human Rights, they have a completely different way to go about it. And, you know, the necessity in a democratic society then has a certain meaning, etc. So and margin of appreciation comes in. So so there's not really one way of doing proportionality, but the German, and that is, I think, the most annoying part, you know, from a legal theory point of view, that they think there's only one epistemologically correct view, and that's theirs. And if you take that attitude, you can forget about legal pluralism. That would be my answer. Anybody else wants to add? I see there are many.
Agree more. Couldn't agree more. This is, I think, also a wonderful quote to close slowly this seminar on, if I may say something like that.
You're absolutely right. We're already a little bit over the foreseen time. So I guess what we can say is that if there are more questions, I think see you all. We'll see each other on Twitter, or at the one or the other occasion here and there, or just you know, write emails and let's keep in touch. And yeah, thank you so much to everybody for participating. We've been up to 100. I see that the number is slowly declining. People are leaving. So wish you all a wonderful afternoon. And thank you again very much, Antonia, for setting this up. That was a wonderful idea. And to my fellow speakers for agreeing so spontaneously to join us here. And I think it was very helpful. I learned a lot, and I hope so did you. And yeah, that's it. Okay.
Thank you. Bye-bye.
Thank you. Bye.
Bye.
Bye.